Hey guys, good morning. Let's get started. Let's take a look at Dejon Anderson and her motion for self-representation. Let's see if we can find some clues here as to whether she's going to be able to provide quality representation for the entity known as Dejon Anderson, or maybe if her rocker is slightly off or she's off of it. So it starts out, I, Princess Califia Hatan Tupac Bey II. And I apologize for getting any of that wrong. I didn't personally know Princess Bey the First either. Anyway, this person or whatever is representing the entity Dejon Anderson and notifying the court of self-representation. How do you self-represent when you are an entity that's representing some other entity? I don't know. This only makes sense to sovereign idiots. But anyway, this entity politely relieves the Washington County Public Defender's Office of their responsibility to manage the case due to a conflict in the case. Is this attorney representing somebody that the state has on their side or something like that? Well, let's see what that conflict is. Public defender attorney is the grandson of Joe Biden. Now, I realize that the entity moving for self-representation may be playing the odds here because Joe Biden does have a lot of grandchildren, but still not exactly sure, even if that were true, how that is a conflict. So whatever. So she cites some stuff here and then says, documents and objects are foreign intelligence information that contain actions of Joe Biden as used in Rule 6 something, whatever, foreign intelligence information. And that means information, whether or not it concerns the United States person, that relates to the ability of the United States to protect against actual or potential attack or grieve hostile acts of a foreign power or its agent, sabotage or international terrorism by a foreign power or its agent, or clandestine intelligence activities by an intelligence service or network, a foreign power or its agents. This is all tied into Joe Biden and her, right? I'm going to skip a little bit of this national defense, etc. This is all how it gets back to Space Force, I think. So anyway, any motions, filings, pleadings on behalf of the entity, Dejon Anderson, by the public defender are null and void, and that he was notified of termination on April 8th, 444 via text through combined public communications provided by the Washington County Jail, and has the phone number here. And I'm sure that was monitored by the NSA and Space Force, who are obviously keeping tabs on where the entity is at all times. So Dejon Anderson on April 3rd, face-to-face conference. I am requesting contact information for the prosecutor and judge to be included in all conversations, correspondence in regard to this cause, and to be present at all judges' chamber meetings as it relates to me exercising the Fifth Amendment, it appears, to the United States Constitution. But why not all the amendments? The whole Constitution. In any way, I, Princess Califia Hatan Tupac Bey II, affirm and certify the truth of the allegations under the penalty of perjury. And then we have this signature. So does that look balanced to you? You think she's just making that up, or does she actually believe any of this nonsense, or maybe some of both? Not sure in her case. You know, and in Brooks' case, say Darrell Brooks, he's just making that stuff up, right? He's just an idiot, but and trying to get off of things. But here, I feel like there's a disconnect from reality, and as well as trying to manipulate the system. And she's filed a bunch of other things too as the case rolls on. There's going to be a competency hearing, and we already talked about that a little bit last week. But I wanted to show her motion for self-representation so you can see it for yourself, judge for yourself. Let's check out Richard Allen's case, because that is still headed for trial on May 13th. It's hard to believe that with so many matters still in the air, but that's the schedule. The judge did dispose of the motion for contempt against the defense attorneys, denying that motion. The judge found them sloppy and negligent and incompetent. That sounds all very bad, and referred them to the Office of Judicial and Attorney Regulation for possible violation of the rules of professional responsibility. Hopefully that's the last we'll hear of that inside this case, and attention can be focused on resolving issues necessary for the trial, because that sideshow, I think, has not been helpful in any way for confidence in the judicial system, for resolving this case, for doing anything positive. So whether there's merit to her findings or in a great way or a minor way or none at all, just get move past that and let's get this case done. So to that end, a hearing is scheduled on May 7th on various matters, including the state's motion in limine. Remember that's where they wanted the defense to be prohibited from mentioning lots of things and the names of certain people, really trying to head off their third-party culpability defense. And that is a potentially critical topic. Some other guy did it, and here's that guy the defense wants to say. Now, again, you don't get to just do that. You can't just roll into court and say that. There's a significant legal standard to meet to make that claim at trial, to actually name somebody else as the person who did it. However, if you have the evidence necessary to meet that standard, you must be allowed to do it. So this is a crux ruling based on the forecast of the defense case you see in the Franks filings. That first Big Franks motion, I didn't think was really going to be adequate to invalidate the search warrant, what was stated in it, but it might be very relevant to this trial that's coming up. And you can see what the defense was going to say. They're going to say, hey, these Odinists did it, and here are the Odinists who did it. That's what they want to say. I don't think it's a secret. So whether they get to do that or not may matter a lot in this trial. And keep in mind, there's a difference between saying, hey, this other person X did it, and pointing that out straight to that person, versus saying the police failed to investigate persons X, Y, and Z and follow up any other leads and trying to show the investigation was not thorough. But here, it does appear the defense wants to point the finger directly at person X. So it's a major issue. It's all coming down next week, and then the trial allegedly to start on the 13th. So let's check out Bryan Kohberger. The state has responded to the Coburger alibi notice, saying it really does not claim an alibi. I kind of feel like at this point they're right. Now the defense says we need more information from the phone to really be able to tie it all together. So it's kind of floating in the air a little bit. The state points out the state's already said he was driving before and after the murders. There's no alibi in that. Hell, that's part of our case. And they reiterate at the time of the murders, his cell phone was not providing data that would establish his location. They say it was turned off. Of course, if that's true, the cell phone and the accompanying expert that the defense wants to call would not provide in any way an alibi, unless it were to report the phone location so far away when it is online and the time of that location that it's so far away that Coburger couldn't have been at the crime scene and then gotten to this other location in the time frame the state alleges. So even if you didn't have the data at the time of the murder, that's a way that could be relevant. But to me right now, it looks like a placeholder attempted an alibi without cell phone evidence to support it. The defense even mentioned there might not be cell phone data to support, but said if it isn't, it's the state's fault. Now, is the state wrong that the cell phone was turned off and instead the state destroyed and deleted the location data? I mean, I certainly have an opinion as to which is more likely, but regardless of that, this really all still comes down to evidence at trial, and there is a lot under seal, including this stuff, so we don't really know the state of it. And that trial, when it occurs in the year 3000, will provide the answers, perhaps. Let's check out Darrell Brooks. He was rolled into court yesterday, which I always enjoy seeing, since he said nobody's going to tell him what to do. He doesn't even get to stand up when he wants to or be where he wants to. They roll him around. Anyway, he was rolled into court yesterday to discuss his case involving Erica Patterson, which starts next week. The state said they were going to amend the charge. I think I heard the first-degree reckless. I wasn't able to hear all the hearing because of the middle of things instead of second, but that's all minor until the trial actually starts, and then Brooks' game will be revealed. There's no evidence that I've seen that he's had a change of heart or come to the Lord or in any way change from his loathsome self, and I think he'll continue to act in accord with his selfish, evil ways. It's really the only point of this case right now anyway, is to do that. And how about the Karen Reed case? Have you been watching that? I have not been able to see the case, only a few snippets, but since it started, I haven't been able to follow it. But one thing that was interesting to me was the fact that she was charged with second-degree murder and not just manslaughter. So let's take a look at the statute there for that and see what that means. Murder committed with deliberately premeditated malice, aforethought, or with extreme atrocity or cruelty, or in the commission or attempted commission of a crime punishable with death or imprisonment for life, is murder in the first degree. Murder which does not appear to be in the first degree is murder in the second degree. Oh, that's helpful, isn't it? If it's not first degree murder, it's second-degree murder. So let's look at something else and see if we can get down in a little bit, and let's check out the pattern jury instruction they have. In order to prove murder in the second degree, the Commonwealth must prove the following elements: the defendant caused the death of the victim. That makes sense. Now, look at this, though. The defendant intended to kill the victim or intended to cause grievous bodily harm to the victim or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. And that's higher than the manslaughter statute, which is a high likelihood. This is plain and strong likelihood. So there's the split between second degree murder, say, and manslaughter. But I feel like, I guess to me, that what I know about the case, which is limited because I haven't been able to watch most of it since it's been going and only know some of it to begin with. I know, obviously, I think everyone probably agree that the defense attorney is doing a great job. And then there's a split as to whether you think that what the defense attorneys are saying is correct or not, which is that he was murdered really by somebody else is their whole theory. And at the very least, that he was not killed by Karen Reed's car with her driving it. So you either think that or you don't think that. But I think the defense attorneys, from what I hear, are doing a great job of trying to make that case out to the jury. But I guess what I wonder is, if she did hit him and kill him, where's the evidence that she intended to murder him? Okay, because the statute says intended to kill him. Is there evidence that she intended to kill him by backing into him and then taking off? Is that I mean, that seems speculation to me. And I know you can infer intent and things like that, but still, this seems, that can't really be the basis for this case, can it? It doesn't seem that way to me, whatever. Or that she intended to cause this serious bodily harm to him. Did she mean to do that? Did she mean to hit him with the car? So I think you could certainly infer B. If you slammed your car into somebody, maybe you intended to kill him, maybe you didn't, but you apparently wanted to harm them, because that's what happens when you slam your car into people. But that would take believing that she reversed the car into him on purpose. And is there evidence of that? Or intended to do an act which, under the circumstances known to the defendant, here Karen Reed, there would be a plain and strong likelihood that death would result. And that to me is very close to B, because what she was doing was backing her car up, which when you're in a car, sometimes you have to back it up, turn it around. So that by itself is not inherently dangerous, a way to create super risk to the public, especially in the middle of a storm. And they're both probably loaded. But if she wanted to hit him, of course, that would do that. Or if she thought, well, I'll back up really fast and make him jump out of the way. If she saw him back there, then I could see that coming under C, because, you could cause death by creating a game of chicken like that with a person who's not in the car and you are in the car. But where's the evidence that's what she meant to do? I don't know that. Of course, I may have missed it, but I guess I felt like the murder charge was a pretty strong thing to put on her in a case where the guy was killed when she was backing up, and so in the middle of the night and stuff like that. So even if she did hit him, I really wonder if this is the right charge for that. Anyway, I'd be interested in what you say in the comments on that, because I know other people have been able to watch the case some and may have some opinions based on the evidence that has come up so far. So that's it. I don't think we had to go too long this week, and I will talk to you later. Thanks. Bye.